Happy President's Day, everybody. It's a special President's Day edition of the Consumer Warrior YouTube channel's live Q&A. Let's get started. All right, my office is closed today, but I came into work to do try to get caught up on some stuff, and so I thought at the end of the day I might do a live stream here and go over a bunch of questions that are comments that are pending in the questions over on the YouTube channel. If you happen to be catching this live and you're on YouTube, go ahead and put a question in there, and I'll do my best to try to get to it today. But I thought I would start by, let's see here. So I'll share my screen, go over some of the comments that I get. I try to get to these, but I can tell you it's pretty hard to do it just because there is a lot of them, which is a good thing. But let me jump into some of these questions here. This first one is a good one here at the top from Donna. She says, what is tolling or trolling contract with a credit card? Being contacted from a bank on a credit card debt back from 2006 to 2016. They state they can still go to court now in 2023. State of Texas, what can I do here? So one thing is I don't know the statute of limitations in every state. So the statute of limitations is the amount of time that they have to be able to collect on the debt from the time it goes into default. And so if it, like in Arizona, it's 6 years. 6 years from the time that the debt goes into default, they have to sue you. There is what's called tolling. When the statute of limitations is tolled, that means essentially it's kind of put on pause. So, for example, sometimes filing a bankruptcy on non-dischargeable debt, maybe like a student loan or something like that, there's an argument that it tolls the amount of time or stops it or extends it essentially that they had to sue on it. So what you want to do, anytime there's a statute of limitations argument, something where you think the statute of limitations is expired, if they file the suit, you got to bring that up, either in a counterclaim or an affirmative defense. That's the one thing with the statute of limitations. It's a defense that you have, but it doesn't mean that if the other side disagrees with you, that they're just going to stop in their tracks and not, continue forward on it. So it's important to go find that out. I do have a video on the statute of limitations where in the comments I put all the statutes from all 50 states. I don't know that off the top of my head for Texas, but you may want to check it out there. So, all right. This next question here from Kenny. He says, can you help me with medical debt collection in Kentucky? Unfortunately, I'm not licensed anywhere else but Arizona, but I am trying to put together a network of attorneys that I think would be beneficial. And can I request private arbitration for medical? The answer there is yes, you can if there's an arbitration clause in the agreement. Medical debt, it's usually unlikely that there is a private arbitration clause. The reason why you can do it with the credit card debt is because in the terms and conditions, it actually has that in there where they can, it states that the parties can elect private arbitration. So that's why you can do it there. With medical debt, it's less likely that it's going to be there with a typical provider. Unless it's like a hospital or something like that, then it could be. Next question, David says, should you still file a response if you're in the middle of doing a settlement? So it looks like here the situation is that you have a situation where they are they're negotiating a settlement, but there's a debt collection lawsuit that's been filed, and so the time to answer it is coming up. Yes, my recommendation is unless you have some type of agreement or something in writing as far as an extension, you need to be really careful with that. And I would file one just to be on the safe side unless you have something in writing that the other side's not seeking a default against you. So I would take a look at that. We do have a question here. Let's jump over here with this one. I'll do with our log home here. If you hire a lawyer, you still have to show up to court in person. I can tell you in Arizona, in civil cases, if you have an attorney who's representing you, you don't have to be there unless they subpoena you. That's one thing you got to be careful of. That there's a subpoena. A subpoena is like a court order saying, yeah, you got to be here. But in Arizona, in a civil case, if you have counsel, you don't have to show up if your attorney is. Like for most hearings, pretrial conferences, stuff like that, you don't. In Arizona, if there's mediation, then you do. But because they usually want the parties themselves to be there as well, but typically you don't have to if you actually have an attorney. So that may vary from state to state, but in Arizona, for sure, you don't have to if you have an attorney representing you. So, All right, let's jump into some of these other questions. I think I probably have to take that off. I'll do this follow up with you here. Log home. How can a lawyer that's in the same state but far away from your county still handle your case? Is it all done online? So a lot of things are done online now. I can tell you, or they're done telephonically. Like I'm in Maricopa County in the Phoenix area. I represent clients all over the state of Arizona. There are times I have to travel to court, but I can tell you that the courts, particularly post-COVID, things are done over the phone. They're done via Zoom. I've done trials via Zoom. I have an arbitration hearing coming up this week that's being done even over the phone. I put a little video up last week showing that I did a trial and it was in person, and it was the first one in person in quite a while. So yes, those things are happening online, and the courts are using technology more, which is a good thing. I mean, it makes it more efficient for clients, particularly in a lot of civil cases, attorneys charge hourly for them. And so if they're not having to travel a long ways, it's going to be cheaper for everybody overall. So, all right, let's get to some of these other comments here. Let's see here. And I'm scanning these in real time. Susie Q says, is filing this? So this is my bankruptcy. Is this expensive? Could I do this myself? It's a great question because, you've got this legal issue with bankruptcy where clearly there's some financial constraints, and that's why you're struggling. It does vary from state to state. The bankruptcy courts do have some regulation when it comes to bankruptcy as far as attorney's fees. I know with like our Chapter 7 bankruptcies here in my practice in Arizona, we do what's called a zero down payment plan. We don't charge anything up front, and then we just do a small monthly fee over a 12-month period. Chapter 13s in Arizona are also regulated. There's a flat fee right now in 2023. The flat fee for a Chapter 13 bankruptcy is $4,500 plus the court's filing fee. So that's across the board. That's at all attorneys in Arizona charge for a Chapter 13. But that's a 5-year process. So that's legal fees over a 5-year period. Chapter 7s are much less expensive than that. So can you do it yourself? Do people do bankruptcies on their own? Yeah, they do. Is it something that I would recommend? I've just seen a lot of people, it's not just filling out forms. For somehow it got this reputation because there are a lot of forms that people can just fill them out. I've just seen a lot of people get into a lot of trouble when it comes to doing it on their own because it can be really complicated. So, there's a number of comments here. Let me jump over here for 1 minute. We'll pull some of these up. Andriana says, hi, the judge orders to go to arbitration. The junk debt buyer's never paid. Jamma, probably Jams there. Should I file a motion to dismiss with prejudice or leave it alone? I would absolutely, it's from Memphis, Tennessee. Awesome. I've been to Memphis. When I was in college, I played college football, played for BYU, and we played in the Motor City Bowl, or not the Motor City, the Liberty Bowl there in Memphis, and it was freezing cold. It was I think it was a New Year's Eve bowl, and it was cold there, but it was awesome. Got to go to Beale Street and all that kind of stuff. But to your question, if they never initiated it, and that's what the court ordered them to do, then yes, I would file a motion to dismiss. I wouldn't just leave it. The courts, you got to realize the courts have thousands and thousands of cases. We all focus on our one individual case, but they're constantly juggling a lot of cases. And so they won't do anything unless you prod them to do it. And to me, I would want to do it before the debt collector, before they take any action. So yes, I absolutely would do that. So Alex, Monday Night Live, we're here. Thanks for supporting the channel from Yuma. I appreciate it. All right. Triple Count says, since the pandemic, has filing bankruptcy increased substantially? And do I see a rise or fall in it in years to come? I can tell you, it was something that was kind of interesting is when the pandemic hit 2020, the spring of it, all of a sudden, people were predicting that the whole world's going to fall apart, the bankruptcies were going to go through the roof, and it didn't happen. And in fact, 2020 and 2021 were two of the lowest filing years for bankruptcies across the country ever since the bankruptcy code, since the late 70s. So, the reason why is because there was a lot of stimulus money. a lot of cash flowing in for people. I mean, you remember back to 2021, 2020, particularly families that had several kids. I mean, they were getting thousands and thousands of dollars were coming in these stimulus funds. And so it helped a lot of people to avoid bankruptcy. There was even a lot of statistics showing that savings, the number of savings was through the roof during that time period. A lot of people had to be able to put some money away. And credit card balances were down significantly. We're seeing a complete reversal of that, where the savings is down. Credit cards are at a record level right now as far as the amount. I just saw a study over the weekend saying that car loans are in default in extremely high numbers. And I can tell you in my practice here in Arizona, the bankruptcy filings in the last 3 months have skyrocketed. I'm working on President's Day, and the reason why I'm working on President's Day, even though my firm is closed, is because I've done 11 bankruptcy consultations today. There are a lot of people who are deal with a lot of difficulty, and the credit card debt's high, medical bills are high. It's just all around. It's become, I think that 2023 is going to be kind of a rough year for a lot of people. Should I respond to a lawsuit? Of course. That's why the whole channel is here. 95% plus of people do not respond to debt collection lawsuits. They end up with a default judgment, and then they end up with wage garnishment and all the other horrible, miserable things. So yes, absolutely respond to the debt collection lawsuit. So, all right, let's jump back into a couple of more of these comments from the channel that I was looking at today. Let's see here. I'll do this one with Ashley here. Ashley says, because I did a video called 3 Tips If You're Filing for Bankruptcy in 2023 in regards to tax refunds. It says, it would have been more helpful if you went into some examples of good timing to keep your tax return, but thank you for the info regardless. All right, Ashley, I'll make amends here. We'll make this right. So this is an Arizona specific thing. And the reason why is because, let's see here. And the reason why is because they don't, we don't have what's called a wild card exemption. So in Arizona, if you file for bankruptcy, the timing of your bankruptcy throughout the year will depend on how much, if any, of your tax refund you're going to have to turn over to your creditors. So, for example, we're here in February of 2023. If you file your tax returns right now and you're entitled to a refund, you would want to get your tax refund before you file bankruptcy. The reason is, so here's the timing. If I'm filing for bankruptcy right now in the state of Arizona, let's say I file bankruptcy and then I file my tax returns and I get a refund. The bankruptcy code and the trustee states that they're going to take your refund and distribute it out to your creditors. However, if you file your tax returns, you get your refund. You use those for whatever reason that you talk about with your attorney, for living expenses, whatever. And then you file for bankruptcy, you won't have to turn anything over. Now that gets you through essentially April 15th. After April, if you file your taxes at that point, you're going to have to provide a portion of your refund that you receive next year in 2024 when you actually file those returns. The later you file your bankruptcy in 2023, the more of your refund you're going to have to turn over in 2024. So for example, let's say you file bankruptcy in August of 2023 and you're in the state of Arizona. When you file your taxes next year in 2024, you're going to have to turn over 8/12, which, let me get my calculator out here. 66% of your refund is going to have to be turned over for the benefit of your creditors. So you want to take a look there. So that's what that's how that works when it comes to tax refunds, particularly in the state of Arizona. So Alex, I don't know if I didn't want to miss you. I thought I put it up there. You said I missed a super chat, but I'm not seeing any other questions. So if there was, let me know. All right. Let's do a couple more questions and then we'll call it good for a Monday night. So I keep getting a lot of questions. Do I have people in other parts of the country? I'm trying to put that together just so that, because I know that this goes out everywhere. Let's see here. Going to see if there's something that could be a benefit to everybody as we're going through this. Getting a lot of spammy comments there from bots of some sorts. I clearly should have read these ahead of time. Let me see here. You know what we'll do? We'll go to Ray's question. It's tough to read through there. And all right. Ray says, should I answer a request for admission or ask for private arbitration? So request for admission, what these are is in a civil lawsuit. They consider a written discovery. Now, written discovery comes into three categories: request for admissions, request for production of documents, and interrogatories. So request for production of documents is pretty self-explanatory. That's where a document is turned over. They're requesting specific documents. You need to respond to that. Interrogatories are essentially just written questions where they want information. Requests for admission are where they're asking, it's just an admit or deny response. They're saying, hey, admit that you owe us $1 million. Yes or no. Those have a pretty significant penalty if you don't respond to them timely. If they're not responded to timely in most jurisdictions, they're deemed admitted. So, for example, in Arizona, you typically have 30 days to respond to them. If you don't respond, then the court can deem them admitted, and then the creditors will often try to use that as like an exhibit to a motion for summary judgment. So, yes, my recommendation is you always respond to written discovery. Even if you're going to request private arbitration, if those are pending, I would just respond to them and then file your motion. All right, Andriana, thank you for that. The super sticker today, $20, man. Thank you. I appreciate that. All right, we'll do one more here. Joshua says, when can someone expect their credit score to improve after all debts have been settled, or is it 7 years the standard? So if you settle out of debt, the first thing you need to do is make sure that they've updated it correctly. So if you pay off the debt, usually takes at least one cycle to be able to for them to update it, and then they should show that it's zeroed out, it's no longer in active collections, it's not derogatory. There may be a notation in the credit report that says it was settled for less than amount owed. Negative information does stay on there for 7 years, but the further you can get away from that, usually, like even with a bankruptcy, it's about 18 to 24 months before the score fully recovers. Sometimes with debt settlement, depending on other factors, and if you have other positive information going on the report, it can be a little bit quicker than that. So, hey, I hope you all have had a good Monday. Hopefully you got some time off. I appreciate everybody checking in here last minute and everybody who supports the channel. If you have other questions, go ahead and put them in the comments. Like I said, I'm going to try to reach to them. Otherwise, we'll catch you here Thursday night, 5:15 p.m. I believe it's Mountain Standard Time right now. And we'll go over any other questions you have at that point. Well, have a good night.